but public safety concerns must be addressed in ways that are lawful.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
When you examine the Supreme Court's docket this term, the first thing that stands out isn't what they ruled on, but what they quietly pushed away with petition after petition involving major Second Amendment questions showing up, and almost all of them met with the same response of denied with no explanation and no written opinion and not even a hint of debate. And when the court goes that silent, it usually means something is shifting behind the scenes. What makes this pattern genuinely stand out is how consistent the rejection has been with hardware cases and magazine cases and sensitive place cases and AR-15 cases all hitting the same wall, while only 2 petitions made it through, and both of them point to conflicts the court apparently can't ignore forever. Why some analysts say the court is waiting for the right case, while others believe the justices want lower courts to keep wrestling with these issues before stepping in. How the silence isn't neutral but deliberate, because when the court chooses silence over clarity, that usually means something bigger is brewing. And the reason, if there was ever a case the Second Amendment community believed the court had to take it, was the challenge to Maryland's ban on AR-15 style rifles, which wasn't a fringe lawsuit but a direct strike at one of the most controversial gun restrictions in the country. Once you understand why, for months, analysts and attorneys and gun rights advocates all said, this is the moment that finally forces the Supreme Court to answer whether AR-15s are protected under the Second Amendment or not. Yet when the petition reached the court, it was denied without comment, which hit harder than a written rejection. How 3 justices were ready to take the case immediately with Justice Kavanaugh, even hinting the court would eventually address this issue, just not now. And what it means that across this term alone, roughly 70 Second Amendment petitions reached the court's doorstep, with nationwide challenges and major splits between circuit courts and questions affecting millions. Yet out of all of them, the court agreed to hear only 2, representing an acceptance rate hovering around 3%. You'll realize the court is letting lower courts fight it out and build conflict and expose weaknesses before stepping in again. And it isn't disinterest but strategy, where the more uneven the rulings become, the harder it will be for the court to stay silent, while the groundwork for a major AR-15 showdown is forming. And once the right case reaches the court, the justices won't be able to sidestep the question anymore. Something extraordinary is happening at the Supreme Court that most people aren't paying close enough attention to, and the implications go far beyond what typical headlines suggest. When you examine the court's docket for this term, the first thing that becomes apparent isn't what they actually ruled on. It's what they quietly and systematically pushed away without explanation. Petition after petition involving major Second Amendment questions has reached the justices, and almost all of them have been met with the exact same response: denied, no explanation provided, no written opinion issued, not even a hint of internal debate or discussion. And when the Supreme Court goes that silent on a constitutional issue this significant, it usually means something is fundamentally shifting behind the scenes in ways the public won't understand until much later. What makes this particular pattern stand out so dramatically is how remarkably consistent it has been across different types of cases. Hardware cases challenging bans on specific firearms, magazine capacity cases questioning round limits, sensitive place cases about where carry is permitted, AR-15 cases directly challenging the most controversial rifle restrictions in the country. They've all hit the same wall of denial. Meanwhile, only 2 petitions made it through the gauntlet and were accepted for review, and both of them point to conflicts between circuit courts that the justices apparently can't ignore forever without creating massive legal uncertainty. So the question becomes unavoidable. Why refuse so many cases so quickly while the issue remains hotly contested nationwide? Some legal analysts say the court is strategically waiting for the right case with the perfect factual record and procedural clarity. Others believe the justices deliberately want lower courts to keep wrestling with these issues, building up conflicting rulings and exposing contradictions before the Supreme Court steps in with definitive guidance. But whatever the underlying reason, the silence isn't neutral. It's deliberate and calculated. And when the court chooses silence over clarity on a fundamental constitutional question, that usually means something much bigger is brewing beneath the surface that will eventually emerge in a major ruling. If there was ever a case the Second Amendment community believed the court absolutely had to take, it was the challenge to Maryland's ban on AR-15 style rifles. This wasn't a fringe lawsuit filed by extremist groups or a long-shot appeal with weak legal foundations. It was a direct strike at one of the most controversial and far-reaching gun restrictions in the entire country. For months leading up to the decision, analysts, constitutional attorneys, and gun rights advocates all said essentially the same thing. This is the moment. This is the case that finally forces the Supreme Court to answer the question everyone keeps avoiding through procedural technicalities. Are AR-15s constitutionally protected under the Second Amendment or not? It's a binary question that requires a definitive answer. Yet when the petition reached the court, the response was nothing, denied without any comment whatsoever. That silence hit harder than a written rejection would have because the lower court's reasoning was widely criticized even by legal scholars who don't align with gun rights positions. The lower court claimed AR-15s were military-style weapons undeserving of constitutional protection, a conclusion that clashed with historical precedent, common use standards, and even previous Supreme Court signals about protected arms. 3 justices were ready to take the case immediately and hear oral arguments. Justice Kavanaugh even hinted publicly that the court would eventually address this issue, just not right now under these specific circumstances. So the case that should have been a breakthrough moment turned into another reminder of how carefully, some would say cautiously, the court is choosing its next major Second Amendment battle. Rhode Island's magazine capacity case should have been a straightforward test of Bruin's rules and historical analysis framework, a state limiting every citizen to 10 rounds, regardless of training, skill level, or documented threat, seemed like exactly the kind of hardware restriction the court would want to examine under its own newly established standard. But when the petition reached the justices, the response was the same quiet shrug observers saw in other hardware cases: denied, no warning, no explanation, just gone from the docket. And that silence matters tremendously because it leaves conflicting standards in place across different parts of the country. The lower court had upheld the ban using historical arguments that many constitutional experts called generous, to put it politely. 3 conservative justices signaled they were ready to take the case and provide clarity, but the rest of the court simply wasn't interested in stepping into another hardware fight. Not yet. This is the pattern gun owners keep running into repeatedly. Cases about people and process, questions about who can carry, and what procedures must be followed seem to get traction with the court. But cases about actual equipment, magazines, rifles, accessories keep getting systematically pushed aside without consideration. It doesn't necessarily mean the court disagrees with the constitutional challenge being raised. It means they're waiting for the right hardware case to arrive with a record so crystal clear and facts so compelling that they have no procedural escape route before they take it. Rhode Island's case wasn't that case, so it disappeared without ever touching the conference table. And here's where things suddenly turn in a direction most people didn't see coming, because November didn't just reject individual cases. It effectively erased almost an entire year of Second Amendment legal strategy in a single brutal conference session. Most people saw the headlines about these denials and shrugged. Just another stack of cases the court didn't take, which happens all the time. But anyone paying genuinely close attention felt something very different. These weren't routine passes on marginal issues. These were devastating blows to challenges that could have fundamentally reshaped who can carry, who can buy, and who the government can permanently disarm.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
When things sound really good for gun owners in court, that doesn't mean it's over.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
Minnesota's age 21 carry case is a perfect example. The lower court struck down the restriction, a clear win for gun owners, and the Supreme Court simply let it sit untouched. That sounds like good news until you realize it only protects citizens inside that one circuit. Everywhere else in the country, the fight continues from absolute scratch with no binding precedent. Then there were multiple cases about universities and campus carry. The court had a clear opportunity to decide whether schools truly count as sensitive areas under the Bruin framework, and they walked right past it. No hearing scheduled, no clarification provided, just silence that leaves students and administrators in legal limbo. And perhaps the toughest hit came with a wave of challenges to lifetime firearm bans for nonviolent felons, all dismissed in a single sweep. Dozens of petitions representing years of legal effort gone in minutes. These denials weren't just paperwork moves. They reshaped the entire battlefield without issuing a single substantive ruling. If there was ever a moment that felt like the court slammed the brakes on Second Amendment expansion, it was November. One conference session after another, petitions poured in, and one after another, they were tossed out as if the justices were clearing a desk before walking out of the room for an extended period. Lawyers following the docket called it the biggest wave of Second Amendment denials in years. Gun owners frustrated by the pattern called it something else entirely. Bloody November. 59 petitions were lined up. Hardware cases, felon in possession challenges, sensitive place disputes, permit issues, serious constitutional questions that could have set national standards. And in a matter of minutes, the court wiped out the overwhelming majority of them without a hearing, without oral argument, without a single clarifying word. But here's the strange part that reveals what's actually happening. When you examine the pattern closely, the rejection isn't random. The court didn't target small procedural issues or cases with weak records. It systematically threw out the cases that would have forced them to answer the absolute hardest questions right now. Who gets rights restored after conviction? How far can states go in redefining what makes someone dangerous? Can outright bans survive without solid historical backing? By sweeping those cases aside, the court showed exactly where it doesn't want to engage yet, and that silence revealed something more important than any ruling could have. The justices are carefully timing their moves, not avoiding the issues permanently. November looked like a shutdown to casual observers, but it was really a strategic signal to lower courts and litigants about what kind of cases the court wants to see. After watching petition after petition fall through the cracks, you'd reasonably think the court was done with the Second Amendment entirely for this term. But then, almost quietly, 2 cases survived the purge. And the fact that these 2 specific cases made it through tells us more than any denial ever could about the court's priorities. First is a case out of Hawaii, where the state tried to turn public carry into something that existed only on paper through geographical restrictions. They stacked prohibitions so thick that everyday locations suddenly became off limits. Parks, sidewalks, parking lots, businesses, even places with absolutely no security presence whatsoever. It was a strategy designed to choke carry rights through geography instead of direct legislation. The court said they'll take a look at that case. Why? Because this challenge forces the justices to answer a question states have been dodging since Bruin was decided. How much of the map can a government erase through sensitive place designations before carry becomes functionally impossible? The second case targets the federal rule banning firearm possession by anyone who uses marijuana, even in states where it's completely legal under state law. Millions of Americans fall into that category, and lower courts can't agree on whether that prohibition survives modern Second Amendment tests. The court couldn't ignore this split forever. So while dozens of cases died this term, these 2 didn't survive by luck or random selection. They survived because the court knows they will define the next major shift in gun rights jurisprudence. When you step back from analyzing individual cases and look at the raw statistical numbers, the picture gets sharper and honestly harder to ignore. Across this term alone, roughly 70 Second Amendment petitions reached the court's doorstep. Nationwide challenges, major splits between circuit courts, questions that affect millions of gun owners. And out of all of them, the court agreed to hear exactly 2. That's an acceptance rate hovering around 3%. Most people glance at that number and think, well, the Supreme Court rejects lots of cases across all constitutional areas. That's absolutely true. But when the Second Amendment has generated more lawsuits since Bruin than at any point in modern American history, ignoring this many cases signals something much bigger than routine docket management. The court is deliberately letting the lower courts fight it out, build up conflicts, and expose weaknesses in various legal arguments before stepping in again with another major ruling. It isn't disinterest in the constitutional questions, it's strategic patience, and the more uneven and contradictory the rulings become across different circuits, the harder it will be for the court to maintain its silence. If you own an AR-15, the court's behavior this term sends a message. But it's not the clean victory or clean loss that sensational headlines would have you believe. It's something much more nuanced. A pause, not a retreat. Maryland's AR-15 ban was widely expected to be the case that forced the court to speak definitively on rifle protections. 3 justices were ready to grant review. A 4th signaled interest, and yet the petition still died without being accepted. On the surface, that feels like a significant setback for gun owners, but in practice, it reveals that the court isn't ready to lock in an AR-15 ruling until lower courts push the issue to an absolute breaking point that can't be ignored. And that breaking point is coming inevitably. Across the country, multiple circuit courts are split on whether AR-15s are dangerous and unusual weapons or protected as common arms for lawful purposes. That division is growing, not shrinking. By 2026, that tension will be impossible to ignore, and the justices clearly know it. The court's silence isn't approval of bans or rejection of constitutional challenges. It's a clear sign they want the next AR-15 case to arrive with a fully developed factual record, conflicting circuit rulings, and absolutely no procedural escape hatch. So where does that leave AR-15 owners heading into 2026? In a holding pattern, but actually a stronger one than it superficially appears. The groundwork for a major AR-15 showdown is forming systematically, and once the right case reaches the court with all the necessary elements, the justices won't be able to sidestep the fundamental question anymore. The wait is frustrating for those who want immediate clarity, but the stage is being built case by case. The court is positioning itself to issue a ruling that won't just address one state's ban, but will set nationwide standards. So that's the landscape heading into 2026. Not a defeat, not a victory, but what can only be described as a loaded pause. The court is choosing its moments with extreme care, and when the right challenge finally lands in front of them with the perfect record and unavoidable circuit splits, it won't just tweak existing rules around the margins. It'll decide the future of AR-15 ownership for an entire generation of Americans. If you own firearms, especially an AR-15, this is the critical moment to stay locked in and informed, not drift away assuming the issue is settled, because the next major ruling won't wait for anyone to catch up after it's announced. The justices are building towards something significant. That's it for today, folks. See you in the next video.